Yeah. That was hard too.
Yes, ma'am.
I couldn't see anybody around it. Sorrowful from the picture.
Going to admit Zoom. I do not see Vice Chair Jakowski on yet. She was not feeling well, so she said she would try and Zoom, but she wasn't 100% sure.
It is 7 p.m., February 26, 2026. Call this session of the City of Bandon Planning Commission to order. May I have a roll call, please?
Commissioner Freeland,
Here.
Chair Starbuck,
Here.
Commissioner Pressler. Here. Commissioner Orsi.
Here.
Commissioner Frey.
Here.
And I do not see Vice Chair Jakowski online, so she must not be joining tonight.
All right. Consent agenda, is there a motion?
I move that we approve the consent agenda.
Second. Motion made and seconded to approve this consent agenda. All in favor, say aye.
Aye.
Opposed? Hearing none, we'll move on. Public comment. Comments from the public on any item not on the agenda, limited to 5 minutes each. To comment in person, please sign in and return the form to the clerk. If participating via Zoom, raise your hand at the beginning of the public comment period. Public comments and the information provided during the meeting will be collected and retained by the city as a public record in accordance with Oregon Revised Statutes, Public Records Policy 192.005 to 192.170 and 357.805 to 357.895, with some exceptions. You can comment on anything not on the agenda. Anybody want to talk? Seeing none, we'll move on. We are now going to have a hearing, public hearing on case number 260004, setback variance at 663 Seacrest Drive. I declare this public hearing open at 7:02 p.m. on February 26, 2026. This is an official public hearing before the City of Bandon Planning Commission for Type 3 public hearing for case number 26-004, setback variance at 663 Seacrest Drive. The applicable substantive criteria are contained in the staff report. Please address your comments to these criteria or the criteria you believe to apply to this decision. Official notice is hereby given that the Planning Commission can consider laws, ordinances, court decisions, etc., without them established as evidence in the hearing record. A copy of the minutes of this hearing will be available in the city offices. A copy of the rules and procedures being read will be available in the city offices as a part of this file. Is there anyone in the audience who wishes to challenge whether it is proper for the Planning Commission to hold this hearing? Seeing none, are there any commissioners present who wish to declare ex parte contact, site visit, feel they may have a conflict of interest, bias, or other reason to be disqualified from participating in this hearing? I will start out by saying that I have been to this site in the past on other agenda items of past meetings. So I have been to this site and it's there it is. Anybody else?
Yes, I received a direct communication and therefore I feel the need to recuse. So I'm going to step out during the hearing and I'll just leave this on the desk in case anyone in the public would like to reference it.
Right.
And I was with you, Don, on that other visit we made to the site. Oh, yeah. And I was with Commissioner Starbuck on that trip.
I've had site visits.
All right. Do you feel it's compromising your?
No, I do not. I know.
Okay. Is there anyone in the audience who wishes to challenge any of the commission members' qualifications to participate in this hearing? Seeing none, we move on. Staff report.
Good evening, Chair Starbuck, Commissioners. I'm trying to get my screen to cooperate at the moment, so please bear with me. Well, that'll do. Trying to get an aerial up for you, but it doesn't seem like it wants to recognize that screen. So as you mentioned, we have a variance request to setback standards. The case file is 26004. 663 Seacrest is our address. It's R1 single family dwelling or single family residential zoning. I'll go through real quickly the findings that are outlined in the staff report. You do have a recommendation of approval before you that the following findings have all been met, and then I'll zoom into the site plan here on the screen in front of you, which is also handed out to y'all on the dais. I'll make sure we're real clear about what the request is. In fact, maybe I'll start there first because there was a little confusion about some of the preliminary notes that were contained in the site plan. So there are only two variance requests under consideration here. The first is clouded in the upper left hand side of this site diagram. It is a setback variance request of 5 feet. So 20 feet is required by R1 zoning, and they're asking for 15. And the second request is on the right-hand side of the property, so the eastern boundary, which is abutting the sloped area. So that's a request of a reduction of 10 feet from 15 feet down to 5 feet. And you'll notice that due to serious slope constraints and geotechnical considerations, the buildable area of this site is reduced substantially. So you have a compromised building frontage on the eastern edge, and then further compromising buildability of the site is this hammerhead configuration and the turnaround, which basically takes a big chunk of the front yard setback out of the buildable area. So with that, hopefully that is context enough for you, and I'll walk through the findings as conveyed in the staff report. So the applicable criteria, as Chair Starbuck mentioned, are contained in BMC 1636040B. There are 6 of them. I'll walk through very briefly what staff findings are for those considerations. The first is that there are unique physical circumstances. We cannot grant variances unless we make findings that there are such considerations on site. And as I've mentioned, Context on site, given steep slopes of 1.3 to 1 or greater, which reduce the buildable area of the site by nearly 60%. So it takes that nearly 18,000 square foot site and reduces it to roughly 5,000 square feet of buildable area. And as I mentioned, the additional context constraint of that front yard setback, which is being nibbled into there on the front right side of the site or the east side of the site due to the Hammerhead turnaround. So you have a unique situation there, which technically this is a side street. So you're on a corner lot because you do have a side street. So that increases that side yard setback of 15 feet. They do comply with that. Technically, the eastern elevation of the building is set back probably 80 to 100 feet from the eastern property line, but it's nearly entirely unbuildable. Number two is the minimum necessary, so that the requested setback from 5 feet, or excuse me, from 20 to 10 and or to 15 rather in the front, and 15 to 5 on the side. In staff's opinion, do represent the minimum necessary to design and construct a home of somewhat diminutive stature. This is not a large home. It is a 2,000 square foot home with small bedrooms, small dining area, co-joined kitchen and living area, and efficiency baths. It is a 2-car garage, which is standard in size to support two parking stalls interior to the structure, which meet our parking code. This is not the consequence of a self-imposed condition, so that's number 3. There, as I mentioned, are 2 physical constraints on site which are unique to this property compared to the remainder of the subdivision. And this request is not the result of any intentional or deliberative action on the part of the applicant, like property line adjustments or other conditions where they're trying to subdivide property and create unbuildable lots. Number 4, the request does not conflict with other regulations. All other regulations in our municipal code that apply to single-family dwellings are met. So this does not apply or is found to be met. Number 5 is that there's no foreseeable harm to any adjacent property. The site is uniquely disposed on the eastern side of the subdivision, which essentially creates one abutting property owner to the west, to the east, and that setback is met at 5 feet. So there is compliance with that eastern setback. So no harm is a consequence of reduced setbacks directed at the abutting neighbor to the east. As far as number 6 goes, all building code requirements, those will be assured to be met through the zoning compliance process and the building permit process directly with respect to building code. But as far as the rest of the municipal code goes, their staff found no other violations or inconsistencies that would rise to a level to make a finding of inconsistency here. So this criterion is met as well. We did receive one public comment, that was from a Mr. Christopher Snell, who dwells at 675 Seacrest. And that was in relation to an erroneous clerical error on the site plan, which indicated there was a rear setback request as well. That's been rectified in the record. So there is no rear yard setback requested. And with that, I'll just conclude by saying that you do have a staff recommendation of approval that all of the aforementioned criteria have been met. That we will ensure that future building permit review substantially conform with whatever approval comes of tonight's deliberation and hearing, and as well as any conditions of approval that you may see fit to add to the project. And of course, SDCs or system development charges will be paid by the applicant prior to issuance of a certificate of occupancy. And that's all I have. I'm happy to answer questions.
Seeing none. All right. Move on to the hearing. This hearing will be be orderly and courteous. When it is your turn to testify, please speak clearly and state your name for the record. The hearing will be conducted as follows. The applicant will go first and be allowed 20 minutes to testify. Those members of the audience who have registered to testify will be called in order and each will be allowed 5 minutes to testify. Those audience members who on Zoom who wish to testify can raise your digital hand and then offer testimony when recognized. After all testimony is taken, the applicant will be given an additional 10 minutes for follow-up testimony. The Planning Commission will then close the public hearing and deliberate. Failure to raise an issue with sufficient specificity to afford this decision-making body and the parties involved an opportunity to respond precludes an appeal to the Land Use Board of Appeals based on that issue. Does the applicant or their representative wish to testify at this time?
I think that Jeff covered everything.
Okay, seeing a negative nodding of heads, we will continue. Public testimony. Are there any members of the audience who wish to testify? Same action is observed. All right. No follow-up, I take it? Any additional comments? Probably not. All right, we will close the hearing at 7:14 p.m. At this point, we will look at commissioners wish to comment.
Yes. Unless someone wants to go first.
Go ahead.
I want to point out to the commission, all four of us tonight, that we are under no obligation to approve a variance. That's in the code, even if all the conditions for the variance are met. And I don't believe they are all met. And I'll go into that in a minute. I disagree with staff on his findings. I think we need to be very cautious in approving variances as a commission so that we do not set a precedent that we have to deal with later. The issue that I have on variances is I look differently at approval criteria number 3, which states the need for the variance is not self-imposed. And I look at that opposite of staff's opinion in that I believe the applicant purchased the property. They were aware of the property's unique characteristics. And I believe now that in essence makes the need for the variance imposed by the applicant. And in that case, I don't feel that variance criteria is met. And that I do not believe we should approve this request.
Okay. Anything else? Staff comment on that?
None.
Okay. No additional comments, so we'll move to the point of a motion. Well, okay, I've already closed the hearing. We can we can entertain a motion to close the public hearing and the record and proceed deliberations or continue the hearing at a future date and time to be specified. So would you want to have a future date and time?
Not for me, no, thank you.
Okay. Is there a motion on this action?
I guess I disagree with your opinion on it being imposed. So I think it was through no fault of the owner that they weren't aware that the slope was there. So I disagree with you on that.
Well, I think the owner stated they were aware of the circumstances of the property. In which case, I think we have a situation here, and once again, I'll caution the commission in setting a precedent. But I believe we have a situation here where someone has purchased a property and now they are trying to conform the property to their footprint of their construction rather than having their construction conform to the footprint of the property. And that's why they're requesting the variances. That's my opinion. And I don't believe that's the purpose of a variance.
Maybe we should have the applicant stand up and make the comment.
Well, we've closed the public hearing, but I don't have a problem with we
Well, we haven't
can
closed.
reopen it, can't we?
We can reopen it.
I make a motion to reopen.
We didn't actually have a motion to close it.
Oh, that's,
I just went ahead and,
okay. No, I agree.
all right.
Yeah.
So it was an error on my part. So let's go back to the applicant now that you've raised this issue, which should have been done with the applicant.
Well, the applicant didn't testify.
Right, okay.
So.
All right, now that you made the comment, the applicant needs to testify.
Hi, good evening. I'm Matt Riley with Vine Maple Design. And I represent the property owner. And yeah, I think as Jeff said, they would like to build a modest 2-bedroom home on this property. And there are geological, slope constraints that they've looked into, I think, since purchasing the property and know more about now. But I wasn't aware that number 3 was that self-imposition. The purchasing a property triggered self-imposition. I thought it was more like an act to physically alter property. So that's new to me, a new way of looking at it. But I think when you look at the plan, you can see things are quite constrained. It's not a big mansion they're looking to build. So yeah, I guess that's kind of.
Are you saying they really didn't look at the property until after they had bought it?
No, I'm saying that they didn't get expert geotechnical engineer and geologists on board until after they bought it.
After they'd bought it.
Getting,
And
so
started
they
looking at the site.
they looked at it, but there's a difference between looking at it and having experts come in and tell you what's going on with slopes.
Okay. Does that change your opinion?
No, I'd like to follow up on a couple items that Mr. Riley looked up. And I think the last one that he stated, once again, I think enforces my opinion that this is self-imposed. If you buy a piece of property intending to construct something on it, is it not your responsibility to do your due diligence before you decide to build? Especially a piece of property like this, where it's very obvious that there is a significant slope on the east side. And I understand from your drawings that this is a modest home. However, I think, and I'm not an architect nor designer, however, it appears to me that you could still construct a modest home on this site without variance. Setbacks reduce. So once again, you buy a piece of property intending, I assume, all along to construct something. I think the fact that due diligence was not done at that time makes it a self-imposed issue. That's just my opinion.
Yeah, I agree that due diligence is important, but there are kind of limits. It's like it's not normal to necessarily do all of that, to have those geoengineers come, pay all that upfront money basically prior to buying. So it does make sense to do due diligence. I didn't realize that purchase was the trigger for criteria number 3 in the first place. But that's, having due diligence, looking at things, and then later getting more information, I think is reasonable.
Maybe we need some more clarification on, not self-imposed.
Yeah, staff's interpretation was that the choice to purchase property under, as constrained as the site is, does not constitute a self-imposition of hardship, but rather, I think the intent of the code, at least as staff interprets it, is, excuse me, through any concurrent or previous entitlement request. For example, we see lots of subdivisions come in requesting lots that are compromised. So if this owner were to say had a 18,000 square foot lot and chose to subdivide or partition, create 2 lots, and one of those lots was the subject lot at 5,000 square feet, and then requested corresponding setbacks to build setback variances to build a home, that would rise, in staff's opinion, to a level of self-imposed hardship. So that's staff's logic for making those findings.
So you're saying that the developer in the process of dividing this section of ground into 2 lots, it was their choice to do so.
If that wasn't the case.
No. What I'm saying is had they chosen, had this property owner chosen to subdivide this subject parcel at 18,000 square feet into 2 separate parcels, let's say, sell one, build on the other, that would be a self-imposed land division that would have compromised buildability of the site intentionally. I believe staff's finding is based on that threshold, not the pure act of purchasing a site, which the city intends to build or be a developable site for a single family dwelling, and through no fault of their own or act of their own, have they further compromised the buildability of the site. It was purely imposed by natural conditions unique to the site that were not shared by abutting parcels. So that's this staff member's threshold for making that finding, which is just staff's. You are the decision makers. It's up to you to come up with find your own threshold that you're comfortable with, to set a precedent for future decisions that would be held to the same standard on equally compromised sites.
I tend to agree with staff on this, as it wasn't self-imposed by the current owners. And that their request is not terribly unreasonable. But then that's my opinion, so.
How about every request similar to this that comes in the future, does that automatically grant?
No,
Why not?
I don't think so. I think we have to rule each request by what we're looking at.
I agree, but what if someone buys a lot and they want a variance? Because their footprint is large of the house, so they want a variance. Isn't that, to me, that falls under the same type of variance as this request?
We've had,
That's just
In
my.
that, in that case, the footprint, the large footprint would be that's through their fault. They want the large footprint.
So maybe our code needs to be altered and say, if you have a large footprint, these variances apply, and if you don't, then you have a smaller setback. That's where we're headed, aren't we? You're saying the size of the house now determines the size of the setback. Where do we draw the line between what's a small footprint and what's a large footprint? If you have a large footprint and you want a 5-foot reduction in the setback, is that reasonable? It would be to me if this ruling goes forward as approval. Now, once again, that's just my opinion. I'm very
okay.
concerned about setting a precedent.
I'm looking at this as they have reduced the footprint of the house considerably. You look at their next door neighbor. That's a large house. And if you look at a lot of the development in Bandon today, a lot of those houses occupy the full buildable space that they can find. This one's not doing that.
Oh, because it can't.
It can't. That's right. So they've reduced the scope of the footprint to fit the lot, but they're still constrained.
So your opinion is if you reduce the footprint, you could have less of a setback.
To try and fit in with the current conditions.
Okay, that's a valid point.
I've seen that, we've seen this commission has seen that before along Beach Loop and on I forget where it is. It's next to Whale Avenue. There was a house there on the extreme north.
I like the triangular.
Yes.
Piece of property.
And they had to fit it within the constraints of that piece of property along with the driveway.
So your opinion is that we have precedent.
In other issues that don't apply to this case.
It's the same thing though.
But it was, they were each dealt with individually. We looked at that.
So what you're saying is we have a precedent to reduce setbacks based on the size of property.
Or the configuration of
or
the
the
property.
configuration.
I think we can,
Be the deciding authority here. If there's a precedent, why wouldn't the community development, why wouldn't they automatically approve it? Jeff?
At a staff level, we'll probably, your point's well taken. In the future with clear and objective standards under zoning code revisions, we will likely see more ministerial, non-discretionary choices to make. In my 35 plus years of experience, I think I may have approved or recommended approval of a small handful of variance requests. And my threshold is based on understanding context and the push-pull relationship between livability of a given residential unit. I think that the fact that we are in an acute housing shortage, particularly single-family homes, particularly in subdivisions that are platted with significant geological constraints, floodplain constraints. So yeah, we're going to be faced with a lot more of this kind of choice, and it's going to be ministerial. This staff member applies, what really falls into a 3-part test for variance approvals with respect to this particular criterion. And I think it's a prior action one, which is the self-imposed implication, the example I cited earlier, which was if you buy a piece of land, intentionally parcel it in a manner that renders it unbuildable without variance, hands down, a recommended denial. If, on the other hand, you buy a constrained piece of land, which is justifiably and on its face constrained, and in this case, I think it rises to that level, through significant slope constraints and the hammerhead configuration, which reduces the front yard setback. And the third would be the no knowledge loophole, if you will. So, for example, you can't, an applicant couldn't claim that they didn't know what the setbacks were and then try to place it on the site. I will say that that was the one that gave me the greatest pause, because they should have known what these setbacks were, and they did know. I made it clear to them when they came in. We worked with them. I worked with Matt closely to look at room sizes and configurations to reduce the footprint. They did take such action to reduce the size of the dining area, for example, which is on the non-constrained side, but is up against the hammerhead. As I said, rooms are small. This is not a house that seems to be too large for an 18,000 foot parcel. It is a house that doesn't meet our standards because it is compromised due to slope constraints and geological constraints. So, to answer Bill's question directly, I think moving forward in a ministerial capacity, we would apply that three-part test to this particular criterion. And I think that when you do get into that threshold of decision-making in a discretionary capacity, you have to weigh all three.
Satisfied?
His points are well taken, as are yours.
Yeah. Good. Any more? I think we can sit down, you know.
What would the
Okay.
what would the alternative be for the individual who owns this property? Would be either, I guess, a much smaller home or a smaller footprint in a two-story home if they want to achieve 2,000 square feet. Is there any other alternative use for this particular property? If you think about it in terms of the best possible use of the property, other than housing. And as Jeff has noted, we do have a severe shortage of housing in this town. I mean, in a way, I think it's commendable that someone would want to build a home on a lot like this. It's clearly required quite a bit of ingenuity to achieve this. I'm just questioning what the alternative could be for the homeowner if they want to have a house on this property other than what they've done.
That's a good point, but I'll point out we have a severe shortage of affordable housing. And that's a house of approximately $300,000 in sale price, which I don't believe this house will come anywhere near to. I'm assuming this would be, yeah, I think this is more of a $500,000 up residence. So yeah, I don't want to confuse housing with this house because I think we have two different criteria.
All right. I think we're done with the public hearing. Is there a motion? Yes.
Make a motion to close the public hearing.
Second.
Motion made and seconded to close the public hearing. Roll call vote, please. Roll call vote. Yeah.
Commissioner Freeland,
Yes.
Commissioner Orsi,
Yes.
Commissioner Gray.
Yes.
All right, now we can continue with our debate.
Point
Between
of order,
commissioners.
we need Chair Starbuck to vote for a quorum, or is that not necessary to close the public hearing?
That's not necessary because she abstained.
So is the quorum then 3?
Well, I'm not sure how.
I believe the quorum's
I think
4.
It's a quorum of 4, which is present. So you have
Yeah.
a quorum
All right,
present.
so even though someone has abstained or recused
Yes.
themselves, oh,
That's
okay,
my understanding.
oh, okay, thank
Yes.
you.
I don't vote
Unless it's-
unless there's a tie. So,
Which there
I'm
won't,
sorry.
which there won't.
which there won't be in this case, yes.
Mitchell, is that correct, what we stated?
Yeah, and Chair Starbuck would also participate if it's needed for a quorum.
Thank you.
All right. So we're now in deliberation by the commission. Any more remarks? All right, I will entertain a motion.
I move to approve.
Is there a second?
Second.
Mr. Fay?
We need to come to the mic.
Second.
Okay, there's been a motion to approve the setback and a second. May I have a roll call vote, please?
Yes. Commissioner Frey, Commissioner Orsi,
Yes.
Commissioner Freeman,
Yes.
Motion passed. Moving on.
Okay, can you hold on one second? Let me grab Commissioner Pressler.
Okay, well, okay. Welcome back. New and old business. Seeing done, or that's on you.
That's none. Nope,
Okay,
nothing on the agenda.
we're not going. Community Development Director comments?
Yeah, I just have a couple of quick ones. We have hired a new planning assistant to replace Shannon, who left last week. Her name is Ann Greendale. She comes with great recommendations and has been very impressive in the short time that she's been with us. She'll be starting full-time in actually next week, and we'll be sitting over there with June, helping in Shannon's stead. And she was a familiar face at the Chamber of Commerce for a while, so you may have seen her around town. She is local, and we're excited to have someone here to pick up where Shannon left off. Beyond that, there are a couple of quick items that I wanted to sort of ongoing staff level items that you'll be seeing more of soon. One of those is our housing code audit. I touched on that briefly during question and answer in this last item. A lot of that has to do with catching our code up with state law. So that's the first level of analysis that consultants have provided input on. The second level of data, if you will, or findings, centers on how far above and beyond state law do we want to go with housing permission across what is commonly referred to as missing middle housing. So that's somewhere between deed restricted, pure affordable housing and market rate housing. So it's affordable by design, tends to be cottage scale, small single family dwellings, certainly multifamily housing, condominiums and so on. So you'll be seeing some of that come forward, hopefully in the next week, month or so, in the form of a joint city council planning commission meeting. So stand by on that. You're going to get a request from us to participate in that. We'll probably shoot for the middle of April is when we're likely going to try to target that scheduling. So I'll be reaching out to you. The second relates to council's direction for staff to pursue research around vacation rental dwellings and their impact on housing supply in town. As you know, we are in a 120-day moratorium on the issuance of VRD licenses at this point, and we're going to be using that 120 days to do some research. I've already started that research. Commissioner Frey's been helpful in that regard for long before I arrived. So we'll, depending on where that goes, you know, it may be that I'll use you all as sounding boards and Bill, if you'll agree to continue to assume that role, then potentially jointly, we can report back to these folks as we find things. I will say that, you know, data reconciliation is the biggest challenge. We have TOT, which is generated from all short-term rentals in town, and that includes hotels, motels, inns, and VRDs. So we're trying to separate those two data sets so we understand financial impact associated with capping VRDs alone. So there are a number of different strategies that ordinance could take. One would be to essentially cap VRDs at existing and permit no more. Another would be to further restrict VRDs by increased saturation regulations. So right now we're at 30% saturation in a 250-foot radius, and you could lower that bar and say you have a lower saturation threshold, therefore you would permit fewer. You could certainly reduce the size of the overlay areas that would allow VRDs as well. So there's lots of different nuances to this code, and it's going to get very deliberative with you all and with council as well. So again, probably some joint sessions at some point in the future. But more to come on that. And that's all I've got for you.
Okay. Commissioners' comments? I'd like to ask one thing. This public hearing, it stays within the planning department, or does it go to city council?
No, the subject, the entitlement you approved tonight,
Yes.
it's approved. Yeah.
All right.
There is an appeal process.
There's an appeal.
Yeah, but beyond that,
Okay.
right.
All right. Other commissioner comments? Oh, you're a quiet bunch.
Okay, let's submit Tom. Thank you.
I just wanted to remind people that there's a birthday party for the lighthouse this weekend. I think Sunday.
Speaking of the lighthouse, do we know where we stand with running electricity out there? That always seemed to be a big issue from some meetings that I've attended in the past. Are you familiar with that? You're just.
No,
Okay, so you're not on the board?
no.
Okay,
People have asked me to join, but
okay. Just wondered, thank you.
Any other comments?
Yeah, there's one thing well, as always, thanks to everybody who participated tonight, and thanks for deliberation by the commission. It was a good lively talk. Thank you. One thing that has come up on VRDs that there's nothing for the planning commission to do, but I just wanted to make sure you were all aware is that there are approximately 60 approved VRDs. 45 of those are legally permitted to continue operating as VRDs with change of ownership. In other words, they're grandfathered in. The new owner does not, and Jeff will correct me if I'm misstating, the new owner does not need to reapply. So that would not come before the planning commission. And those are approximately 45 VRDs that were approved prior to, I believe it's October of 2018, where a transferability clause was put into the code to where a new owner had to reapply for VRD status. So we have about 75% of our VRDs, to be crude, we're stuck with. Anyway, I just wanted to make everyone aware of that. And Jeff did a lot of extensive research on that. Thank you. And it was reviewed by the city attorney, and she confirmed that that's the case. So.
do we know about the ownership of those? They owned by groups of people or?
I don't have that information yet, but even if they were owned by a group, and my understanding is even if they were owned by a group or a trust, and then that changed, they would be grandfathered in and could continue.
I was just wondering, looking at the list,
Oh, okay. Yeah, I don't.
how many of those were stuck with?
Yeah, 45. Everything that was approved prior to October of 2018. So there are only 15 VRDs that we've approved subsequent to October of 2018.
I would just add, thanks for that prompt, Commissioner Frey. The criteria that existed prior to 2018 did not have that very robust item K, which has all those VRD specific criteria. They were just sort of like garden variety CUP. And a conditional use permit prior to 2018 would allow any kind of use that's conditional to the zoning code. And in this case, a short-term rental in a single-family neighborhood. And the only way a CUP goes away if it's inactive for a year. So we're monitoring those. So if a VRD is inactive for 1 year, regardless of its permits tenure, we could revoke that, and well, it automatically becomes null and void. So that's the only way they go away.
Okay.
Well, I assume unless they violate ordinances or something, and then you have,
Yeah, and there's other abatement proceedings we can take if there are other code violations. Yeah,
Such as not paying the TOTs.
correct. Yeah, they're still subject to the permit, the regulations that are embedded in the rest of the municipal code. They just don't have the front end transference and other, there's a handful of others, but the transference is the most significant.
All right. Any other comments? All right, it is 8:49, meeting adjourned.
I got a copy of that.
What's that?
I got a copy of that spreadsheet.
Oh, you did? Okay.
It's first time
I've
in
seen it.
Excel, so the first thing I did.
Okay.
Was, I started filtering it.
Got it. Okay. And I think that's.
And I saw Vicasa as the owner of so many of them.
Is that more the property? I think
Yeah,
that
but they
part.
weren't under the property then.
Oh, interesting. Oh, I didn't know they actually owned some property. That's interesting.
Well, they probably don't, but they're probably taking care of.
Well, you know, finance has never reconciling their data. Even when the issue came up a couple of years ago that they weren't, basically they were taking the money in, but booking it, and leaving it at that. So they had no idea what anything was or wasn't paid, or if they were paying correctly. They never looked at their amount. I hope they're doing it now, because how would you know the amount was correct? And some sort of a, if someone remits $100, that's kind of, yeah, right. Either renting it for the minimum number of days or paying. So yeah, this is good. I've never seen this thing like. Okay.
Transformers and stuff.
Hey, well, thank you. Thanks for coming. Oh, yeah. Yeah, it is. Yeah, hopefully, yeah. It's a unique piece of property, that's for sure.
Beautiful now.
Oh, yeah.
Next door. Right.
Yeah, it's a short street. I think there's
Barely
only.
a street. There's one house, one or two houses.
Yeah.
on either side.
I know it's no.
Yeah, I don't know who
And
decided
you
that.
can't go any further.
Yeah, because it basically runs right up the slope.
So just to.
Yeah, that's what I meant.
Yeah.
The hammer's not necessary for people to turn around.
No, I think the plan is, yeah, so. You guys
Thank you.
consider there's a flexible distance.
Because there is a piece of property opposite this one, kind of